Thank you everyone for joining me today. Happy to talk about a new subject. We're talking today about supported decision-making in Arizona. We're also going to talk about it more broadly, but as this is a new topic to many of us, I want to just kind of start broadly and look at what we know, what we don't know, and what we still need to learn, but excited to get started. So with that said, I can see a few attendants currently who I recognize and know, and I say hello, but if you don't know anything about me or we haven't met yet, my name is Emily Taylor. I'm an Arizona licensed attorney, been practicing for about 15 years, grew up in the Midwest, moved here to go to ASU, switched allegiances for law school and went down to U of A for a couple of years, and happy to report I've stayed in Arizona the whole time. I'm a member of the Special Needs Alliance, as well as the National Academy of Elder Law Attorneys, as well as a number of other things, but really interested in kind of diving into this topic today. Obviously, there's a picture of my team here. They're all lovely if you haven't met them yet, so happy to answer any questions as we move forward. So just a little bit about me. But we're going to start today just as a reminder, talking about decisions, because that is the topic at hand, and that is making decisions and an individual's right or ability to make decisions. And I think it's a good reminder. So in preparing for this conversation, you know, I've reviewed what other states are doing and nationally and internationally, but most importantly, I've kind of tried to refresh my sense of remembering I don't know what I don't know. And so I just want to think and talk more broadly about making decisions here briefly, because it's a good reminder for me and for us about all the decisions we each make every day. And so it's just afternoon when we're recording this, but for many of us, we've probably made close to 100 decisions already today. We decided to get up and out of bed, whether that was on the first alarm buzz, or perhaps it was on the last alarm buzz, or perhaps you have a pet that serves as an alarm. We all, I think, hopefully got dressed. We picked out some clothes. We determined and decided whether it was appropriate for what we knew we had on the day. We each make decisions about going to work or not going to work. We perhaps have decided to get married, probably not today, but in our lifetime. And for me, most importantly, I've decided what to eat. I enjoy a good snack. I asked one of my team members to grab some cookies during the lunch break. I have made some decisions, good or bad, about what I'm going to consume and how that's going to impact my energy and my health for today and in the future. We also get to make some other fun decisions, sometimes dangerous, sometimes inappropriate, but who's to say? So we all get to decide from time to time if we're going to resign from a job, if we're going to give away some of our money, perhaps to a friend or a family, but sometimes to a charitable organization. We make decisions about how we spend our time, how we spend our money, what we consume, and for better or worse, if we're not being told otherwise, we keep making those decisions independently for ourselves. That being said, a lot of times as we make those decisions, we're looking at our community or our support network and thinking about who are our supporters. And supporters is a term that's going to come up as we start to talk about supported decision making. But for many of us, we perhaps have parents or grandparents, or perhaps they've passed. We have adult children. We have teachers, we have advisors, maybe we have lawyers. Sometimes we have a stereotypical bad boy boyfriend or acquaintance who likes to smoke cigarettes. I don't know. Sometimes we have a very attractive female supporting us. We're going to kind of look through and think about supporters and what that looks like for each of us, as well as for those we're thinking about supported decision making for. This, in reflecting on this, is a lot of who are my supporters. So personally, when I have to make a decision, who do I look to? And so you get to see a glimpse of baby Emily there on the left. My two best friends, who are still my two best friends, met 24 years ago, and they've made me, or not made me, but they've helped me make a lot of decisions throughout the years, for good, better, or worse. I have some of my team members on there. They help me make decisions about the office and the practice that I run. We've got my immediate family, my brothers, my parents, got my boyfriend, we've got my aunt, my dog, some of my other friends. I know it seems silly that my dog doesn't necessarily make decisions using words, but he helps me get up and remind myself that it's a good decision to go for a walk. And she reminds me what time I should get out of bed. So each of those supporters plays a different role. And so when I need to make a decision, the first thing we need to consider is, do I get to ask for support in making that decision? And that's a really fundamental first piece we're looking at, is when somebody needs to make a decision, do they get to make it themselves? Or when they're asking for that support, are they looking just for emotional support? Are they asking for logistical or literal help, calling, doing something, talking to a government agency, making a doctor's appointment? Do I want support in the sense that I want somebody to make a decision for me? Or do I just want to vent? So with each of those things, we can see that our support provides a lot of different opportunities, and it's driven by the person who needs that support. But what could go wrong? And so as I've thought through preparing this presentation, and we're obviously going to get to a lot of legal stuff, just coming back to the basics of who gets to make the decision, who gets to ask for help making decisions, what types of decisions are we making, and how can a supporter be a good supporter to that person? What could go wrong? Well, at the end of the day, I've reminded myself, I think, in my life, my supporters are supporters, and they can support me and should support me in the way that I need or request. But at the end of the day, I am the decision maker. That's not always appropriate, and so we need to figure that out. But I also added Athena in as a co-decision maker, just because she gets me out of bed in the mornings. But what could go wrong? Well, I know that after a long day at work, I just want to go home and I'm sharing dinner with my partner and we're chatting about our days and I'm venting about a subject at work, which he may not be familiar with. I don't actually want his advice or direction, and I don't want him to make decisions for me. That might turn me into a bad mood. I know as a young adult, when my parents heavily weighed in about what type of career I might be appropriate, those supporters and those decisions, we just have to learn how to be a good supporter if we're stepping into that. So I just kind of wanted to bring all these things up because as I prepared today's presentation, I was reminded how much I assume and presume about myself personally, about my clients, about the adult individuals I petition for guardianship for. And there's just a lot of basics related to decision making that from time to time we can kind of forget about. So as we carry on today, I just encourage you to think about your own life, your own ability to make decisions, how supporters have helped you and will continue to help you, and what may be appropriate in your situation, and whether that's you individually as a parent, as a professional, as a guardian, all of those different things. So with that, let's put ourselves in the shoes of all of these people we work with day to day, whether that's our eccentric grandmother who may make some decisions, or perhaps it's somebody who has a terminal illness, perhaps it's a young adult who has a developmental disability, perhaps it's an older adult who from time to time struggles with making decisions. Let's try to put ourselves in the shoes of all of these other individuals as we kind of think through supported decision making and how it changes the legal landscape and the options we have here in Arizona. So when we think through this, of course, you know, broccoli, TV, a lot of us are involved in how much money is given, medications, all those types of things. So let's get back to specifically supported decision making. So this terminology has been around for some time, but what is supported decision making? Well, as we just reviewed, supported decision making at the end of the day is a couple things. Now, legally, when we're using this term, we're talking about the process that allows individuals with disabilities to make choices about their own lives with support from a team of people that they choose. So that's very common in terms of our decision making for ourselves and also creating the support. But what is supported decision making in the law? Sometimes it's a written and witnessed agreement. Sometimes it's an informal arrangement, meaning we don't necessarily have the written agreement, but we've got powers of attorney, we've got processes, we've got an informal support network. Supported decision-making is a part of person-centered planning. And it's also a less restrictive alternative to guardianship. And so in the law, we need to remember that it can still be a number of different things. But at the end of it, or at the core of it, we're really talking about supporting someone in making their decisions. And if we really break that down, as we've kind of reviewed, it's really about that decision making and how can we set up that appropriate structure to make sure it happens in the best way. So a bit of history. How did we get here? Basically, internationally, we've got some movements that started in the 80s and 90s. Sweden and Canada started different processes related to this concept of supported decision-making. But the big thing that really brings this terminology and this legal piece into play is the 2006 United Nations Convention on the Rights of Persons with Disabilities. Now, the US has not ratified this, but it has major impact on what we're looking at and what our laws are doing throughout the country. So importantly from that, we recognize in that all persons should enjoy the legal capacity on an equal basis with all other aspects of in life, and that parties and states shall take appropriate measures to provide access by persons with disabilities to the support that they may require in exercising their legal capacity. And so this idea that this overly, in some cases, restrictive or formal guardianship process was impacting persons with disabilities and their basic human rights starts to really grab a hold of a lot of different agencies and areas. In the United States, we still have not yet ratified it. However, what it led to was a number of series of conferences that started in the United States. So in 2011, 2014, conferences nationally start being held related to person-centered planning. And the National Resource Center for Supportive Decision-Making was founded in 2014. From there, each state started to consider whether or not they were going to add laws to their statutes that provide for a legal mechanism like supported decision-making. And one big other influence on the national level was that in 2017, the Uniform Guardianship, Conservatorship, and Other Protective Arrangement Act, which I usually just make up some way to pronounce that acronym, for many of us practitioners led to the ability to transfer guardianships and conservatorships from state to state. But importantly, it also provided in that act that before appointing a guardian, a court must specifically determine whether supported decision-making is an appropriate, less restrictive alternative, or not so specifically supported decision-making, but whether there are any supported decision-making, or any less restrictive alternatives. And so currently under that act, there is no specific provision for supported decision-making, and so it kind of was up to each state. So if we look at the timeline then, back to the 80s and 90s, these concepts get introduced internationally. In 2006, we have a huge Convention on the Rights of the Persons with Disabilities that addresses a lot of things, but one of the important things is this coming back to person-centered decision-making and the person's right and ability to have support to make decisions. In 2015, Texas is the first state to enact a statute. In Arizona, for the last couple of years, for kind of as long as I've been looking at this, a bill has been introduced in Arizona. Sometimes gets zero traction. Sometimes it got a little, but until this year, we hadn't really had any footholding. And those who followed this 2023 legislative session, we saw a lot of changes. And what happened is that we had a number of bills that were introduced. And in the end, one of the bills that was successful, kind of at the 11th hour, got some language related to supported decision-making. June 20th, Governor Hobbs signed it into law. And as best we can calculate, it's going to go into effect in mid-November 2023. Now that date is based on when the session ends, and so that's a little bit of a question, but we think it's going to end in a couple weeks. And once we have that in place, then we have 90 days before it goes into effect. So right now, as we're talking about supported decision making, we're thinking about this legal concept. It's also just a concept about making decisions. And so we're going to talk about how that fits in with all of the other things we have. So under the new law, we have the concept of an adult continuing to be able to legally make their own decisions, but creating a supportive decision-making agreement. And under that agreement, the individual names supporters. And so within that, we want to define what the supporters can do. And the big things that the law points out is that the supporters can assist the adult in understanding the options, responsibilities, and consequences of the adult's life decisions. And so if I think back on my own life, you know, like I've said, we all had supporters and we all are probably supporters for others. Supporters under the law can also assist the adult in accessing, collecting, and obtaining any information that's relevant to that decision, including medical, psychological, financial, educational, or treatment records. They can assist in understanding, and they can assist in communicating. So what does that mean they can't do? They can't sign legal documents on behalf of the individual or bind the adult in a legal agreement. They cannot intimidate or otherwise deceive the adult to gain the supported decision-making agreement or any of the authority provided in the agreement. They cannot be compensated for their services, and they can no longer continue in this role once the agreement has been terminated in writing, or if that adult is later determined incapacitated under a court of law or a court has appointed a guardian. So what are the consequences? Well, this framework of putting this supported decision-making in our law gives us the ability to hold and create a structure that we can follow, but it also allows us to have a mechanism for pursuing or giving consequence to those who do take advantage of somebody inappropriately. And so we've had these laws as it relates to somebody financially exploiting the elderly or the vulnerable through a power of attorney. We have criminal prosecution and civil penalties also available under the supported decision-making agreement. And so there are a lot of thoughts about supported decision-making. I'm going to try my best to not address many of those, but one of the big thoughts or concerns is that this supported decision-making agreement has some risk as it relates to vulnerable adults. And so allowing for these consequences to be in there is a step forward in making sure that we can use the laws that were granted to have some formality and some risk to those who are going to attempt to take advantage of the situation. So what is not supported decision-making? Well, supported decision-making is not determining, having a supporter determine what might be in that adult's best interest. It's not substituted judgment. It's not stepping in and making a decision for them or in lieu of them. It's not someone else making your decisions. And in fact, this just keeps coming up as I've prepared for this webinar today. Throughout my day, you know, I just finished a meeting with some clients where we're talking about long-term care planning and setting things up for a parent. And we were meeting with that parent as well as some adult children. And we were joking about this, right? That person is very much a confident adult and able to make her own decisions. And despite the fact she brought her adult children along for support and to take good notes and remember, they don't get to decide. So these concepts, as you can see, really start to overlap. So what is supported decision-making? It's really a legal tool that is a new tool in our now legal toolbox that will work for some, but not for all. And that's going to be one of the hard parts in determining as a young person approaches the age of 18 or later in life if somebody suffers mental illness or some other level of change and needing support for making decisions. I think, you know, if we look at the broad picture related to supported decision-making, a lot of the conversation, both locally as well as nationally, has been focused on developmental disabilities, but this is not true under the law. Supported decision-making is available to all adults. So what legal tool is appropriate? And that's going to be the question that may get posed to you if you have a young child nearing the age of 18. What is appropriate? Is it supported decision making? Is it powers of attorney? Is it guardianship? Is it legal guardianship? It's going to get posed to professionals. So whether we're attorneys or financial advisors or trustees, looking at which tool is appropriate is going to be so unique. And it's just something that is going to be really interesting to work through each unique situation and analyze what's appropriate. And so today I'm going to walk through the primary legal tools that we have so that we can start to look at this. We're going to talk a little bit about the actual agreement for supported decision making, but just trying to give some framework to think about the pros and cons of each of these different areas and how, now that we will later this year have formal supported decision making under our statutes, how we can analyze where that falls in. So as you can see, if we're looking kind of at the spectrum of decision making, on one end we have complete autonomy, meaning an individual, an adult, makes all of their own decisions. On the other end of the spectrum, we have guardianship. And so in Arizona, a guardianship under our statute, a full guardianship, is a permanent adult guardianship that does take away or remove a significant amount of rights. Now, our laws are clear that it does require consideration of that less restrictive alternative we talked about. So when we're pursuing guardianship, the court currently expects and is going to continue, perhaps even more so, that the petitioners for a guardianship are analyzing the other less restrictive alternatives, which you can see here are a limited guardianship, perhaps carving out certain rights or certain duties of the guardian, not taking away all of the decision making. A formal supportive decision-making agreement, meaning the contract or the document that's proposed under our new statutes gets reviewed, gets signed, gets implemented. We've got formal declaration and agreement as it relates to who the supporters are. Informal supportive decision-making, usually that's kind of combined with a power of attorney, meaning we informally have a support network that helps or assists the adult in making decisions based on their request for assistance. Powers of attorney, a lot of times powers of attorney can be a tool that is used when an individual is incapacitated at a later date, but how can we perhaps use the laws that create powers of attorney as a less restrictive alternative to guardianship, while complete autonomy really is a combination of making decisions, but also hopefully autonomously deciding to put into place powers of attorney just in case in the future that ability to make decisions changes. So I'm going to walk through quickly kind of some of the pros and cons of these different legal mechanisms so that hopefully it can help you consider in your situation, whether you're a parent or a professional, what is the right mechanism here for your situation. And so the first one we're talking about is powers of attorney. So powers of attorney and the legal presumption to sign a power of attorney is that somebody has the legal capacity to do so. It empowers an individual to put together that support network, usually people they trust and rely on, who they believe will be available to make decisions for them. Powers of attorney can be medical, mental health, financial, some combination of those. In general, some of the pros for a power of attorney are they're inexpensive. In Arizona, for example, we have the Attorney General provides free healthcare directives, both healthcare and mental health care directives. They're free, so you can print them off as long as they're notarized or witnessed. They're really easy to obtain and they're quick to complete. Presuming I have ink in my printer and a witness available, I can print one off, get it signed, and make it effective within a period probably of 5 minutes or less. They're also easy to change. So if my support network changes, so does my power of attorney. And so that's good. We have some fluidity there. Now, in certain instances, if we're thinking about an adult who has a diagnosis that may impact their ability to handle executive functioning skills or tasks or activities, they may have some compromise in their ability to make decisions, or perhaps might compromise their ability to be vulnerable to perhaps picking or allowing the wrong supporters to be in place, then some of the downside of the power of attorney is it can easily be revoked. And so while somebody turning 18 may, of course, lovingly trust their parents, or perhaps not, they do have that in there. If the wrong influence comes in, it is really easy to change that power of attorney. The other downside is that the presumption legally is that adult still gets to make their own decisions. So when any adult signs a power of attorney, that does not change their ability to sign or complete a contract or to make their own decisions. And so contracts that are entered into by an adult who retains full capacity are presumed valid. So if my new boyfriend takes me to the car dealership and suggests that perhaps we buy a car together as a very romantic gesture, and of course it's common nature that they're going to want to run my credit as well, and perhaps I could co-sign on the loan. Well, that's pretty charming, but the fact that I have a power of attorney in place in no way changes my ability to enter into that contract. And so that is both a pro and a con. So if we start to look kind of at the other end of the spectrum and we consider guardianship, many of you are familiar with the full guardianship process, but very briefly, guardianship is a big deal because what the court is determining is that an individual is incapacitated. A lot of some of the things we talked about as it relates to person-centered decision-making and people first is that guardianship uses really archaic language that may not be appropriate, but guardianship, once in place, once you've gone through the due process steps to make sure it's appropriate, is well recognized. And so here in Arizona, for example, our DDD organization, our schools, our doctors are primed to look for or ask for letters of guardianship. And if you can produce this magical document, it's very clear, it's very black and white, whether or not somebody has the power to make decisions for another person. Guardianship also allows for easy annual reporting. Once it's in place, there is an expectation that reports are filed. There is, under the law, the potential that a guardian evaluator could do a surprise visit or check on something, but largely, as long as the guardian is filing their annual report of guardian, a guardian continues on, and it is permanent until somebody petitions the court to produce otherwise that an important decision, such as terminating the guardianship or converting it to a limited guardianship, or now potentially terminating the guardianship with the indication that they're also going to enter into a supported decision-making contract, can be done, but it takes effort. And it takes a lot of cases, attorneys, they've done a good, they being the state or the county has done a good job of trying to make the forms and documents available for pursuing guardianship on your own or pursuing the termination of a guardianship on your own. However, for those who are not familiar with the court system, it can be a very overwhelming process. And because sometimes people will want to have attorneys in place, tends to be a little bit more expensive. It is not the least restrictive alternative. It is the most restrictive alternative. Guardianships, as far as we can get without imprisoning someone, that that makes us look at the less restrictive alternatives, but that is not what guardianship is. And so it can be a very expensive and stressful process. However, it also can be very appropriate. And so that's why each case is going to be so different. In each case, we're going to want to evaluate where we fit in on that. So somewhere in between, as we kind of went through that lineup of the different range, is a limited guardianship. And so the pros are we start to empower the adult, the individual subject to the guardianship. It is a less restrictive alternative. We are not removing all of their rights under the law. We can protect specific fundamental rights such as voting, and in some cases driving. We can also carve out decisions related to marriage, that type of thing. It also still grants an authority. By authority, I mean letters of limited guardianship that are recognizable by DBD and by Altex and by the schools and doctors. And it also means we have an open court case. And so if there were a change suddenly and we needed to go back to court to perhaps turn it into a general guardianship or even to terminate it, we have an open court case, and so that may be more accessible to us. Of course, the downside to a limited guardianship is that it's still going to require all the due process protections. We still are taking away a lot of rights. It has the same fees and costs in terms of the general guardianship, and it still has the annual reporting requirements. So we can start to see where some of these things come together. It's going to be a hard decision to make. Now, informal supported decision making, this is basically what those of us not under guardianship and without a determination of incapacity have. We have informal supported decision making in place. We have friends, family, professionals that we rely on to support us in making decisions. It empowers us. It allows us to sign powers of attorney. It's very flexible. We get to decide who we trust and who we don't trust at a moment's notice. And at the end of the day, we are our own decision maker, so that complete autonomy. It also allows for increased independence in terms of being able to make decisions, but also decide, who we want supporting us and when we want help or support in making those decisions. The downside is there are no legal protections in place in case we make a bad decision. We're allowed to make decisions. We're allowed to make good decisions. We're allowed to make bad decisions. Doctors, DDD, for example, the powers of attorney or informal support typically don't hold up against HIPAA or rules of confidentiality. So we run into a lot of roadblocks or hurdles. It also doesn't prevent the adult from making their own decisions or contracting. And so in some cases, that's an issue. And it also, both a pro and a con, it can quickly be changed. And that support and individual can be cut out quickly. So with the formal supportive decision making, which is what we're coming up with here as we work our way towards November and have these statutes in place, is a decision making agreement that is formal. And hopefully it helps kind of close the gap between complete autonomy and guardianship or limited guardianship. The goal is that it has a lot of pros in the sense that it empowers the individual. It provides some of that flexibility in the sense that we're not going through a full formal court process. It has some autonomy, or it maintains that person's autonomy ultimately, as long as the supporters are acting in accordance with the rules that they've set forth. It's soon to be legally enforceable, both in the sense that we'll have that document to hopefully allow us to gain access to some of the things we need to support someone making decisions. And it also provides penalties and punishment for abuse, which is a good thing. The cons are, of course, a lot of this is overlap. It's still very new. And in fact, because it's not even a law effectively now, we're going to run into some hurdles, some roadblocks in terms of general public education, education for school systems, for government systems, for anybody who's looking towards the things they know. As an attorney, I run into this all the time. I will have clients go to a bank and try to use a power of attorney or try to collect an asset by beneficiary designation, and the bank doesn't understand these different things. So this is just going to be a learning process, and we don't have all the answers right now. But hopefully, like I said, it's a tool that's going to allow us to get there. So the goal is that we get to a place where supported decision making is a part of our vernacular and people are familiar with the concept and allow us to use it in a way that truly does as intended and support the person, the adult, making the decisions. Of course, there is opportunity for the wrong supporters to still negatively influence the adult. Way back in the beginning when I was talking about the types of supporters, we all know, especially for a young adult, but probably for all of us, love can do strange things. And so whether that boyfriend or girlfriend or husband or wife comes into the picture, there's opportunities for individuals to still use the wrong tools or mechanisms to get involved in somebody's life. And this could prevent or could allow for them to have a legal mechanism to take advantage of somebody. Now, of course, they've put into place some of the ways we're going to be able to protect against that, but hopefully that's the case. It still doesn't prevent an individual from contracting. And so, you know, the contracts they enter into, whether that's a marriage or a car loan, are valid contracts, and we have to deal with the consequences of those. And the adult can change the agreement or the supporters or end the agreement quickly. And so to rely on it when things get tough, when somebody with perhaps mental illness is cycling through some different behaviors, it's a less strong way than guardianship to allow for somebody to continue to support the person in that way. The question that all of us are asking, I imagine many of the people in here, is it going to work? And the answer is, we don't know. And in fact, on a national level, there's still even too little research or evidence that we can rely on to show that it works or it doesn't work. But it's important. We know that it's really a human right to make decisions and to ask for support when you want support, and to take that support and take it into consideration. It provides a lot of autonomy, but it also gives an opportunity for an individual to continue to gain skills to make decisions on their own. And I think that's really important, especially with young adults. I ask clients all the time when we're doing estate planning, you know, at what age do we think our children are going to be mature or responsible enough to make decisions about finances? And that goes from 18 to 65 and probably above. But for each of us as human beings, I think the important thing is we need to see if it works. We need to consider and try less restrictive alternatives, and giving us this tool of a supported decision-making agreement is really, really helpful. So, you know, in that lineup, we're thinking, well, what's this going to look like? I'm going to go ahead and pause for a second, stop sharing the screen. And I'll remind you that as we go through this, please do consider typing in questions and answers. I've got a few in there I can see that I'm going to address here in a minute, but I do want to reshare my screen and show you kind of what we've put together based on the language that is provided in the statute. This is very much a work in progress, and largely this is just the language directly from the statute. But when we're thinking literally about supported decision making in the agreement we're going to put in place, what we're thinking about is something that might look and act like a lot like a power of attorney or a will. We want some formality. We want some language in here. So as you can see, I hope on my screen, we're defining some of these pieces, part of the agreement, what the purpose of the agreement is. And so under our statute, it provides that the agreement is to support and accommodate a decision maker to make informed decisions and choices about certain aspects of their daily life. We define what a supporter is and what the job of that supporter is. And so it's going to be getting that information, the ability to make decisions and choices, and the best personal decisions, but again, not substituted judgment. We're not telling them what's right for them. At the end of the day, if we can make decisions, we get to make good and bad decisions. It goes through and formally outlines what is required to terminate the agreement, which is very common with, for example, a power of attorney. It defines, and I think we probably want our supporters to agree to their limitations under the agreement. So not being able to make a decision on their behalf, not to receive financial support or compensation, and that their duty under the document is to act in good faith, act with loyalty to the decision maker, act without self-interest, which can be hard. And saying that from personal experience, it's really hard to help somebody make decisions that might impact you, that don't self-serve. Avoiding conflicts of interest. I think inherently in a lot of our lives, with our supporters' lives, there's probably some conflict of interest, but that's directed to the supporters, so they're not allowed to consider that. and to stop serving as a supporter at any time you question the capacity to continue making decisions even with your support. And what that means is, I think that at some point, if it appears or the individual believes that the supported decision-making contract is not appropriate, that it's going to be important for them to pursue another alternative, and that might be the limited guardianship or the full guardianship and determination of incapacity. And so as we're walking through this, you can continue to see that the supporter decision-making agreement would end in the event a guardianship was in place. One of the important things here that's also outlined that we can kind of see similar lines in our guardianship laws is that the decision maker, their supporter must respect the other relationships they have with friends and family members, and not to attempt to isolate or alienate the decision maker from those friends and family members. And I think this speaks to a number of situations where, whether it's divorced parents, bad influence, friends in the neighborhood, whether it's those new love interests or relationships, that it's clearly stating that the supporter shouldn't interfere with those decision makers' relationships. And again, I think that speaks to some of it. So under Section 5, we're supporting, or excuse me, we're appointing a supporter or more than one supporter. We, of course, want to have some contact information making them available. And then we're specifically outlining in what areas or limitations do they have ability to support decisions. Now, again, how this is going to logistically work is going to be a big question. But you can see a number of examples here related to obtaining food, clothing, and support, mental health, physical health, managing property or money, getting education or other training, finding a job, services and supports, and then a HIPAA waiver. We always want to make sure HIPAA's out of the way if we need to gather information. We also have some information whether or not we want to allow for our supporters to have access to our FERPA, Federal Education Information Protection Act, so Privacy Act, sorry. So making sure that that's also in there. This can have an ending date, or we can say that it's continuing until such time as it ends by operation of law or the appointment of guardian. It includes some signatures. The law requires witnesses. I think out of an abundance of caution, I threw a notary stamp on here just because it sure would be nice. You know, the information or the things I start to think about is logistically, how are we going to have this signed? Are we going to facilitate family meetings? Is this all going to be very informal? Are people going to create their own forms? Are organizations going to present forms that are kind of fill in the blank and check mark? Or are we going to spend time designing this unique to the individual? These are things we don't really know. I will say that I've spoken with a couple practitioners who practice in states where supported decision making is the law and has been the law, and their experience is very mixed, and it's just not all one direction or another, much like guardianship and much like relying on powers of attorney. So you can see here, you know, obviously the consent and acknowledgement of the supporter, as well as Schedule A, which is contact information for the supporter, including basic contact information, but also preferred method of communication, as well as an explanation of the relationship and history with the decision maker. So this is just a sample or an example based on the language that got approved in the Arizona statute, which of course can change. And so we want to keep working on it, but I think the call to us as family members, as professionals, as people working in this area is to make the use of the law that we've been given as best we can to add that tool to the toolbox. So with that, I'm going to start addressing some questions. See, a couple came up here. So one of the questions is, could they have more than one supporter? And so, yes, I think the idea is that it's a team, if that's appropriate. And so the law does allow for them to have more than one supporter. I think, as we know, we can have co-guardians, but usually that's limited to 2. The court's hesitant to do 3 or more. So there will be some of that conversation as we're setting up these agreements too. You know, when I'm talking to clients about powers of attorney, they say, oh, I want all 5 of my children to be my financial power of attorney. well, I know that that's not going to really work. And so we're going to have some of those conversations about how we design this and how we implement it. So one of the other questions was the sample document had an option cannot make decisions for. Would this override a power of attorney as a result? I think ultimately what's going to happen is that when we're signing a supported decision-making agreement, the adult is also going to be signing powers of attorney, and those power of attorneys, well, yes, there are some free generic forms. There are also documents that we can draft to work in accordance with the documents. So it's really going to be a series of documents that are going to work together and hopefully not conflict with one another. So I think there's a difference between a power of attorney in some instances, whether it's effective immediately or if it's effective only upon incapacity. We're going to have to think through and design our documents to work both together and independently. So I think it's really important. That's a great question, but we want to make sure it all works, because if somebody walks into my office with an estate plan that's done at different periods of time and has information conflicting and some portions are canceled out by other portions, that doesn't work, and it's not a legal tool that's going to be helpful. In this case, I think we just want to make sure that the supported decision-making agreement is a part of the agreement that works well with all the other documents. One of the questions is related to an adult daughter who's on the spectrum, along with other diagnoses, and she does not like to make decisions for fear of making the wrong decisions. I don't like having to make so many decisions on her behalf, but as I tell her, things have to get done. I don't really want to have her declared incompetent or incapacitated. Would a power of attorney be a lesser overall way to go? And I think the answer is there. If she has the legal capacity to sign both the power of attorney as well as the supported decision making, it might be something that both of those things working together would give you some of those tools, because I anticipate part of it is, one, there are certain things you can make decisions for if that's her wishes, and she can put those in a power of attorney. On the other hand, a supportive decision-making agreement can allow you to put into place your role in helping her learn to make decisions, to express her interests, to weigh in. And so I think it's probably a combination. But yes, generally, power of attorney is a less restrictive alternative to a guardianship. And in a large part, it's going to come down to perhaps what her doctors or you and she agree is her actual level to make decisions or capacity to make decisions, and combining some of these tools. But as we've kind of described, supportive decision making is one of the less restrictive alternatives. So what is my interpretation of getting information? Do you think the supporter would be making a call to give that information, or would they have to have the individual with them on the phone? So I think this question is very similar to an adult child telling me, hey, my mom's now incapacitated and I have this power of attorney, but when I call Fox, they won't answer my question. I think, unfortunately, this is going to be part of the growing pains of getting these contracts or agreements in place. I think the idea of getting information is going to require certain legal pieces like HIPAA or confidentiality and writings as related to those. But also I think that the organization that you're trying to get the information from is going to have their own set of rules on how they interpret this document and how they use it to allow a supporter to get information or give information. So just like I warn everybody when they have to go off to all the financial institutions and provide some legal documents, every institution could potentially respond differently. And so it's just something that we have to run into. So with that said, I think I answered all the questions, unless we see a few more pop up. So please feel free to do that here in the next few seconds if you have more questions. But otherwise, I'm gonna share my screen one more time just to kind of wrap things up. Oh, I asked you if you wanted any questions, so a few more minutes to think about that. But I also wanted to say thank you, because I tried to kind of run through a lot of different topics, but I want to remind everybody, or if you missed the first couple of minutes, the important thing is to kind of slow down and think about decisions and how we make them and how humans make them, and make sure we're respecting that and considering that in all aspects of our life, but specifically with our young adults, our aging parents, our sick family members, to try to remember to think about our presumptions and assumptions when we're supporting someone, and making sure that we only support them in making decisions in the way they're asking for it. And so whether that's asking for advice, allowing them to vent, teaching them on how to get information, it's going to be a combination of all these things. And at the end of the day, while the law is new, the concept is not. But I think it's really important that we all remember that as human beings, we have this right to make decisions. And if we can use this tool to continue to support our loved ones, I think it's a great alternative to some of the limited options we've had so far. So I hope kind of this walk through all the different legal processes has helped. I am going to follow up this webinar for those of you attending live with a link to the recording, as well as I'm happy to share with you that draft version I put together. I would hope you would not rely on it or use it without further legal advice. And as I mentioned, the laws don't formally go into effect for a couple more months here in Arizona. But I think it's going to be a very interesting way of looking at all of these things. And so I would encourage you to continue to follow along as the laws continue to change. And it's something I hope to keep talking about because I really love the topic. It really kind of opened my eyes and just reminded me about the importance of a lot of things we do as professionals and as individuals. So thank you for watching. And if you need anything, I encourage you to follow us on social media to make sure you keep up with what we're doing. I do quite a few webinars from time to time, but sign up for all the newsletters that you can in terms of other professionals locally that can share with you on how this is developing. And it's going to be exciting to see how we use this. So with that, I will thank you all for your time, and I'm going to go ahead and end the meeting. But I am happy to help if you need anything. Please don't hesitate to reach out. Thank you.